Good evening, everybody. It's your friend Rick. It is April the 23rd, 2018. If you'd like to find out how you can get my affidavits, approximately 40 plus that you file in court against child support, to your employer, to the banks, to the clerks, to the driver's DMV, a bunch of places, you're covered pretty much. Okay, because what I've done is, for over a year now, I've accumulated a lot of affidavits while trying to help people, and I just throw them in there because there's always going to be coming along the backside with a similar problem. Okay, so my email is rick, rick0327@me.com. Please understand I do not speak on the phone. Okay, it's nothing personal. It's a policy I've had, and I'm maintaining it. Also, please understand that I'm not hawking my paperwork, so I do not have to kiss your rear end for you to send money to receive my paperwork. Okay, I'm here to help people, but I'm not a whore. Okay, so if you need me to kiss your butt, it's not happening. Okay, I have something you need. It's for less than $200. Okay, it's definitely worth the risk. Okay, this guy here, Mike G, will tell you it's worth the risk. Okay, what I have here is an email from Mike. He's from Pennsylvania. He filed the paperwork before going to court. They made him wait 4 hours, and the case was dismissed. Okay, so he's a very happy man. All right, I sent him the paperwork. When did I give it to him? I think sometime in... Well, I've been dealing with him for a while, but he prevailed. Okay, had some woman trying to take him for some money. He filed paperwork before going to court, and here we go. Here's the email right there, and he's a happy man. All right, so we have another dismissal. Okay, and let me get rid of this. Okay, get rid of this. He's in Pennsylvania, and let's move on. All right, so what I've done is I'm trying to keep it simple for you guys, okay? And what I've discovered is every state has a constitution, and citing Supreme Court, citing federal law, we're always met with trickery. Okay, there's always somebody who's not prepared, who's nervous. It happens, I understand. And if you cite your rights, some creep judge or fake judge will claim that the federal laws do not count in state court to see if you're prepared, and a lot of times people aren't. So what we're going to do, let's focus on the state constitutions. Okay, every judge or fake judge, they're bound by their state constitution. There's no finagling for them. Okay, and what I've found in every state, you are entitled to a trial by jury. Okay, they cannot take that away from you, and that's the only way that you're going to be ensured of a fair trial. So if you're one of these people with a support order, 99.9% of you, I'd say 100%, you all have judgments by either a judge or a non-judicial person or a fake judge. Okay, don't call them fake judges. That's something between us that we share, but they're non-judicial persons. Okay, quorum non judice, and they have no personal jurisdiction over you because they're pretenders. Okay, you are entitled to due process, and due process is synonymous with a trial by jury. Okay, so what I did was I accumulated, I took 6 constitutions and I looked them up. I have them, I have all 50 of them. So what we have here is Arizona. Okay, Arizona, the supreme law of the land is the Constitution. So they can't pull that bullshit with you if you live in Arizona. Well, the federal laws don't count here. Well, yeah. All right, Section 3 of Article 1 of the Arizona Constitution says, the supreme law of the land is the Constitution, and it's the supreme law. So that means any law that is contrary to the Constitution is void, and you're allowed to object. Okay, and you can stand on your tile. You can stand on your tile and keep objecting till the cows come home. There's no ways around it. Okay. Here we go. Trial by jury. The right, get used to seeing this. The right of trial by jury shall remain inviolate. Get used to seeing that. All right, that's in every state. Inviolate. Okay. Oh, also, I keep forgetting. Guys, do me a favor and next to my my name, my channel. Hold on, guys. It's loading up slowly. Slowly. All right, I got my new Mimi, whatever you want to call it. All right. Right here, and subscribe. There should be a bell icon. I don't know what the hell. I guess I can't see it because it's my channel. Do me a favor, click on it, and if you're notified of a video of mine, just click on it, like it, please, and just watch it. If you don't want to watch the whole thing, watch it for a few seconds. It comes up as a view. I'm just curious. For some reason, my views are, kind of slow, and I'm wondering if I'm being monitored. All right. I mean, I got 7,000 subscribers, and it takes a few days for me to reach 1,000 views. Okay, and it wasn't like that for a while. All right. So just when you see that a video has popped up from me, click on it, watch it, watch the whole thing, watch it for a few seconds, but just watch it. All right. Do me that favor. I appreciate it. Okay. So you're going to click on that bell icon. All right. All right, so that's Arizona. Oh, 1 second. Arizona and okay, 1 second here. That green is annoying me. All right, all right. You got equal privileges. It's equal rights. All right. Writ of Habeas Corpus. All right, shall not be suspended. All right, every state has that as well. All right, so I believe that the writ of habeas corpus is the way to go here. And they're going to fight us on it. But the way the case laws are written for the writ of habeas corpus is that it's the great writ. It does not need to be used if somebody is being physically restrained, meaning sitting in a jail cell or in a prison. When you are being deprived of your rights, or in our case, a void judgment called a support order, you are being restrained of your liberty. You're not allowed to live your life the way you want to live it because you have this hanging over your head. All right. The Supreme Court, Meyer versus Nebraska, it's a 1923 case. It's 100 years old, has not been overturned. Says that the restraint of liberty need not be physical restraint. Okay. And also other cases like Harris versus Nelson, it's a 1964 case, says that writ of habeas corpus can be used basically to bypass the procedural mazes, meaning you don't have to file a order to show cause, you got to file this and file that, because they want you, they want you to believe that you have to give the courts an opportunity to fix their errors. Well, we don't have time for that, okay? Every day that a order exists is a day of pain and suffering. So you don't have time for that. And there's a New York case, People versus Schildhaus, and being that every state must honor a judgment from other states, okay, they have to honor this case because it's a New York State Court of Appeals. That's the highest court in New York, and they say that the writ of habeas corpus is the great writ, and it takes precedence over everything, meaning the man that filed it, they were trying to argue he was supposed to file an appeal, and the court said no, he does not have to file an appeal. The writ of habeas corpus, it takes precedence over a appeal. Okay. People versus, should come up because I use it a lot. There it is. People versus Schildhaus. If those of you not up to snuff, this is Google Scholar. It's an excellent tool, and download it. It's free. And you got the star icon here. That's favorite. So I click on it. It's in my library now. And what I like to do is I like to click on where it says cited or how cited. So you see how other courts in other states or in the state of New York are their interpretation of it. So here it is. The right to invoke habeas corpus historic writ is so primary and fundamental that it must take precedence over considerations of procedural orderliness. You understand? It does not have to follow procedures. It goes right to the top. Okay? Also, this is a matter where there was a non-judicial person, see, quorum non-judice and void. So this was a void judgment. They used this for a void judgment. Okay? And look what they, here, see they're citing People versus Scott, that's a case, and look what they cite, the United States Constitution, Article 1, Section 9, that's the writ of habeas corpus. New York Constitution, Article 1, Section 4 is writ of habeas corpus. Okay, so I'm showing you how it's used. So that means you can use this case right here and use it in your state to show that you take this case as a state case, and then you use it. You could also use it with the Supreme Court, Harris versus Nelson. Let me look that up real fast for you guys while we're here. All right. Harris versus Nelson, it's in my favorites. All right, let's see how it's cited. Here, this is my favorite. The writ of habeas corpus is the fundamental, this is why we can use this to save us from support orders. Okay? The writ of habeas corpus is the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state actions. Okay? That's what we're dealing with. Okay? And it's very important. And let me see here if I can find it. Anyway, look it up. Okay. The great and efficacious writ in all manner of illegal confinement, as this court or writ to provide prompt and efficacious remedy for whatever society deems an intolerable restraint. Does not have to be a physical restraint. Okay, and somewhere in here it says that it could be used to bypass the procedural mazes. Okay, because every state has their own procedures Okay, and we don't want to be bothered with that. We want to get this over with. Every day that this stupid support order is hanging over our head, here, look, they talk about interrogatories. All right, look this up when you get a chance. Okay, but what I'm doing here is I'm showing you that the writ of habeas corpus and the trial by jury are two weapons we're going to use against these people. Okay, and every state constitution affords us this. Okay, California, Section 9, the right of trial by jury shall be secured to all. And here we go again, remain inviolate. But in civil actions, 3/4 of the jury may render a verdict. It doesn't matter. We want you want a trial by jury. That's all we're asking for. All right, don't worry about the 3/4 thing, because there's a different preponderance of evidence is needed for a civil action. The privilege of the writ of habeas corpus shall not be suspended. Okay, get used to seeing that. Constitution, State of Florida. They use Declaration of Rights, not Bill of Rights. Trial by jury shall remain inviolate. Writ of habeas corpus shall be granted. And this is what's great about Florida. All my people in Florida, freely without cost. So you could petition for writ of habeas corpus and it's free. That's great. Okay. Texas, search and seizure. Okay, see, search and seizure is in every state as well, and search and seizure is for these income withholding orders. Okay, you could file a writ of mandamus to compel them to provide a court order. Well, they cannot. What they provide, your employer I'm talking about, what they provide is a income withholding order, and it's an administrative order. Okay, writ of habeas corpus shall never be suspended. Okay, number 5, Constitution of Tennessee, right to trial by jury shall remain inviolate. What I like about Tennessee, look at this one they have here. This is also proof of what I was. They cannot. Your due process requires, because we're guaranteed a trial by jury. What happens after a trial by jury? You're going to get a judgment by peers. And by the way, a judgment by peers cannot be appealed. So that's it. So if you're rendered, innocent or whatever, not guilty, it's forever. They cannot appeal it. All right. This is that no man shall be taken or imprisoned or disseized of his freehold liberties or privileges, or outlawed or exiled, in any manner destroyed or deprived of his life, liberty, or property, but by the judgment of his peers or the law of the land. Okay? That's everybody. And this is just Tennessee, but I'm telling you, throughout the United States, you cannot be deprived of life, liberty, or property unless by a judgment by peers. So when you're in court, you're going to demand a trial by jury, and you're not going to move away from that. Because I'm showing you right now, I'm just giving you an example of 6 states. Trust me, when you have nothing to do, go look it up yourself. It's in every state. Okay? Pennsylvania, Declaration of Rights, trial by jury shall remain inviolate. Search and seizure, warrants, habeas corpus. Now what they do is they're slick. They add like the bail with that, but that doesn't apply. Okay? See, then there's the semicolon, and the privilege of writ of habeas corpus shall not be suspended. They do this to make you think that you have to file a writ of habeas corpus only in, issues of prison. That's not true. Okay, it's a slick move on their part. All right, so I just did a quick video showing you guys that you are all guaranteed a trial by jury, which shall remain inviolate. A weapon that we can all use is writ of habeas corpus, okay, because our liberties are being deprived. All right, trust me, we're going in the right direction by doing this, because I've had people file them and we're being met with a lot of resistance, but we're just going to have to keep breaking through. Somebody's going to break through, okay, because it's in every constitution, every state constitution. All right. So I'm going to end the video now. All right. So remember, you are all guaranteed due process. Due process is synonymous with a trial by jury resulting in a judgment by peers, which shall remain inviolate. Okay, guys? And a writ of habeas corpus is something you could file right away because it bypasses the procedural mazes, and it's the great writ. All right? And I'm done talking. I got to stay quiet because it's nighttime here. All right, guys. Have a good night.